Bethesda decides to send a threatening letter to an individual who is selling his video game through Amazon. Basically, a guy decides that he wants to play a game. I actually forgot the name of the game. Something Evil 2. Damn, I forgot the name. Anyway, Bethesda game, right? So he buys it for the PS4, intending to buy a PS4 because he didn't have one. Then decides instead to upgrade his gaming computer instead. So obviously, his purchase of the PS4 game is useless, and he decides to sell it. He never opened it. He obviously never used it, never cracked any seal on it. It's absolutely brand new. He puts it on Amazon for resale, something that I've done with physical products many times before. Sometimes I buy something and I resell it on Amazon. It's absolutely brand new. There's really no difference. I don't even open it. But he tries to sell it, and he gets a threatening letter basically demanding that he stop, or at least at least not claim that his game is actually new. He says it's a brand new game, which it is, right? He never opened it, never played it, never used it in any way. They want to say that it's not a new game. And they're basically threatening under copyright and trademark law. The question is, can they do it? How does that make any sense? So let's get back to it. It is a complicated issue. And before we start, I'd like to tell you that this is not an area where the law has settled, where I can tell you this is exactly what the law says, and this is not. As we go through it, you'll understand the permutation, and a lot of time how the court has handled it or decided just to punt it off, let Congress deal with it at some point in the future. But basically, what we have is copyright law, right? And copyright law basically grants us a limited sort of monopoly in our creative work, right? So in a creative video, I put it up, I get copyright in that video. It's a monopoly. I have certain rights to that. There are certain exceptions to that monopoly, but that's essentially it. So let's take a look quickly at here. In front of us is the copyrights, the right attributable to us under copyright law, and it said subject to section 107 through 122. The owner of the copyright under this title has the exclusive rights to do and to authorize any of the following. And now we have a bunch of stuff here. And if you look at number 3, that's the one we're dealing with here. It's the right to distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership or by rental, lease, or lending. So what is it saying? It's saying that when somebody has a copyright in a work, he has an exclusivity when it comes to distributing it to the public. Basically, he's the only one who can sell it. If Bethesda's creating a video game and you gain copyrights in the video game, they are the one who have exclusive right to sell it to the public. So how do you get used sales or any sort of secondary market sale or gray market sale, which is part of what's the issue here? Well, because there's an exception. What we were looking at is actually section 106. And if we go to section 109, this is the exception. It says, notwithstanding the provision of section 106.3, which is the one we're talking about, the owner of a particular copy or phonorecord lawfully made under this title or any person authorized by such owner is entitled, without the authority of the copyright owner, to sell or otherwise dispose of the possession of that copyright or phonorecord. And this is what people call the first sale doctrine, right? Or copyright exhaustion doctrine. The idea is that once the owner of the copyright has sold it out, right? He can sell it for money, or for that matter, he can give it away for free. His copyright, when it comes to a particular issue, which is distribution, is extinguished. And now whoever received the ownership has the right to resell without asking the copyright owner for any rights for distribution. Now, you have to understand a few elements within it. This is an exception only to the right of distribution. Nothing else. So we're going to go through a lot of other reasons. People say, trying to use the first sale doctrine as the basis for other reasons they're allowed to sell. Like, why are they allowed, for instance, to sell ROMs for video games, saying it's under the first sale doctrine. I bought it at some point in the past. I should have entitlement to it as a digital copy. It is absolutely not appropriate under this section for a lot of other reasons. We can get into that at some other point. But there's a lot of different excuses people try to use the right of first sale under, and it's only an exception under the right of distribution, meaning that you have to have acquired the copy lawfully. You have to be the owner of that copy versus other kind of ownership like licensing of that issue, and you have to be able to transfer the ownership of that particular copy, which is can be a problem in some instances. So you have to be the owner, you have to receive it legally, and you have to be able to transfer ownership of a particular copy of it, meaning the one that you own, not create another copy, because that violates other elements within copyrights. What were cases the court has looked at before? Well, when it comes to physical products, the courts have unanimously upheld the notion of first sale doctrine. I buy this phone, I pay for it in full. Obviously, if I owe something underneath it, there's issues. But if I pay for it in full, Apple loses all rights, all distribution rights to that phone. It doesn't lose any other copyrights with respect to the phone, but distribution rights it loses. It gets extinguished. I now can sell it any moment I want to for whatever price. That has been used in many, many cases to justify and to authorize basically gray markets. A lot of companies, watch companies, video game companies, publishers of books, try to prevent the creation of a gray market where people buy products, maybe at a discount, and then resell it back to the market. They may go into other countries where those products are sold for less amount and bring it back to the United States and resell it. And the notion when it comes to physical product is that you cannot use geography as a means of restricting first sale doctrine. Basically, you are allowed, once you have sold it into the market, or once you've distributed it, let's say even for free, your rights of distribution is extinguished. People can sell it. So when it comes to physical product, it is settled law. Right of first sale stands, and once you buy something, you can resell it. No real issue. Now, even early on, when the courts have looked and actually were ruling on this whole notion of first sale doctrine with respect to products, they already raised that issue of, well, what if ownership is not exactly as we see it? What if it's not a true purchase of ownership rights, but rather something contractual, effectively a license? And they started recognizing the issue that effectively, if you don't have certain elements of ownership within the product, the rights of first sale do not apply. Now, over time, its application have become problematic, and we don't really have what I would say settled law with it. Obviously, in the beginning, what we had are physical product that embody elements that is then licensed, right? So, like in the case at hand, a game, but before that, music and movies. Basically, the purchase of, let's say, CDs with a digital product already in it. And we have disparate legal cases, some that say that first sale doctrine applies, some say that first sale do not apply, based on the idea, ultimately, that, there's no ownership of the product. Ownership did not change. Remember, that's one of the elements of that we have to do, whether or not ownership has actually changed. And in the process, a test has been developed that has been used, but it has not been used consistently. So it's hard to say that this is how we're going to look at it. But basically, there was a case out in California that looked at the resale of a very expensive commercial software product. And the judge, looking at it, whether or not resale is permitted, developed a test. And he said, well, first of all, is the license, the EULA, the agreement that you click on when you upload or install the program, does it say that you're an owner, or does it say that you're a licensee? Second, does it actually restrict your ability to transfer the product? Does it say that this license is not transferable? It's get extinguished. Your right of usage under the license is extinguished if you transfer. That'd be number two. And three, it says basically, are there really restrictions on usage of the software in this case? Why? Because unlike ownership, if you buy something, you can do virtually anything with it, unless it obviously breaks the law, do something, let's say, criminal. But when it comes to a license is a right to use. It's not direct ownership. You are granted a right to use it under certain circumstances, and it's limited. You can't do anything you want with it. So he said, I'm going to look into the license to see those three elements, including whether or not there are restrictions. And what kind of restrictions can you have? Well, you can have restricted geographically, saying, you're only allowed to use it within the United States. It's not a piece of software that you're allowed to export elsewhere. You may restrict it by saying it's only for non-commercial use. It's only for usage within a specific industry. You can create restrictions on how people use the software, and that would make it more likely to be considered a true license for the purposes of the first sale doctrine. Now, there are other cases that applied the same thing and came to different results. So right now, the whole issue of physical product with digital media on it is unsettled law. Now, obviously, we have a lot of that, right? We have GameStop, for instance, that sells used games. How can we have that in place? Well, there seems to be some sort of kind of a standstill, right? I mean, an unspoken resolution between all the parties that has permitted the growth of of uh, of used games and used media, as long as it's embodied within a physical product. And there were reason to it. There have been many lawsuits. There are still some lawsuits in that area, but there are concerns on both sides. On the side of the large media company, it is that there have been accusations of the abuse of intellectual property, abuse of copyright, abuse of trademark, basically antitrust, when these companies are actively trying to pretend that their intellectual property, that copyrights, gives them rights far beyond what they actually have, in order to actually prevent the sale of their products at reduced prices, trying to kill the gray market, basically collusion for the purpose of controlling and raising prices on the consumer, which is classic antitrust. Those were threats that have been brought up, and settlement have been the result of that. So within this particular scenario of physical media with digital media on top of that, that's been somewhat unsettled law, but there's been an acceptance that this is going to be okay in the marketplace. So you don't really see straight out lawsuit on that. We'll talk about there's some lawsuit related to that, but not straight out lawsuit just about that one matter. Now, when it comes to pure digital, right, your download of music, your download of books or anything else, the law is pretty settled there. There is no right of first sale, right? And it's not because the courts say it's obvious to them that there is no such right. It's rather than say it's obvious that Congress never contemplated it, and it's up to Congress to fix it. If they want to grant the right of first sale to purely digital products, one that don't have any sort of physical embodiment, then it's up to Congress to do it. The courts don't want to step in and create a right that otherwise didn't exist, that Congress didn't really think of. It's not as if this is somehow coming out of the Constitution. This is a right that was created through the Copyright Act by Congress itself. So when it comes to purely digital product, right? Just a purely digital, where there's no physical embodiment, the right of first sale does not apply. Meaning, you buy a digital book on the Kindle, you're not permitted to resell it. You download your game, you're not allowed to resell it. So yes, if you buy a physical book, you can resell it anytime you want to, but you buy a digital download, you're not allowed to resell it. Now, what do we have here in this case? Well, there is a claim that the product itself, right, which is basically a physical embodiment of a digital product, because it's a DVD with a CD with a game on it in a closed environment. Why is Bethesda pushing for that? Well, they came up with this notion here, right, that there is also a warranty attached to it. And they put in their warranty that if it's ever transferred, since we are not permitting transfer of the game itself, so if the game ever transfers ownership, the warranty is void. And they're saying, well, if what people are getting is with a voided warranty, then when they are reselling the product, effectively it's not the same product that we sold. So when they're selling it, claiming it to be new, it effectively is a trademark infringement. And what does a trademark infringement have to do with this? Until now, we spoke about copyright infringement. Well, effectively, the idea is that, if there are labels on product, you buy a Ford car, there's a label on it. You want to resell it as long as it is what it was in the beginning, right? If you bought a brand new Ford vehicle, you used it, and you sell it as a used Ford vehicle, there's no real issue. That's a right of first sale. But what if you buy a brand new Ford vehicle, you take out the engine, you put a Toyota in it, and you resell it claiming that it's still a brand new Ford vehicle? Obviously, there's a whole issue of you lying as part of false advertisement. That's a separate issue altogether. But the claim, and that has been held to be true, is it's also a trademark infringement because you are misleading people to believe that what you're selling them is actually a Ford vehicle, when in fact it's a Ford shell with a Toyota car in it, right? That's effectively what Bethesda is claiming through this, that since he bought it and since the warranty is no longer valid because of the transfer of ownership, the minute he sells it, he cannot claim that it's brand new here. And that's how they're getting around the idea that there was almost like a ceasefire when it comes to lawsuits about the resale of digital media embodied in a physical structure. This by saying that it's really not a copyright infringement, it's a trademark infringement because it's not really the exact product that we sold, but he's claiming that it's actually sold. That's effectively the kind of issue you have, which is very, very confusing. So before we go on, and lots of comments, let me just give you my 2 cents on what I think is going on here. Physical product rights of for sale. I'll respect what the courts are saying, that unless Congress steps in, they don't want to create a right that doesn't exist in copyright law. So for now, until Congress acts, there is no right of for sale in purely digital products. I believe that when it comes to physical product, there is a right of for sale, regardless of the inconsistency among the different circuits, that in fact, when you buy a product, you have acquired ownership of it for purposes of distribution, and the original owner's distribution right are extinguished at that point. The argument against it is that all these digital media, even when sold in a physical format, are subject to a license, and that license usually specifically say, and in Bethesda's case, it says it as well. I've checked their own EULA, their own license. It says it's not for sale, it's a license, and it's not transferable. The problem is that if I buy a DVD in the store, I've not agreed to any contract yet. I have not opened it. I did not break a seal. I did not upload it. I did not click accept on the EULA. I purchased it, right? At that point, it's a pure purchase, not subject to any real agreement besides some retail measures of me paying for the product. But other than that, there's no real agreement. I have not agreed to the EULA. It'd be inconceivable that even though I've purchased it, that right of ownership, the right of distribution, would then be extinguished later on, even though I haven't signed any sort of license agreement that actually would have described my purchase as a license versus a pure purchase. So I believe that as long as we go to a store and actually buy physical media, housing digital media, that the right of first sale would apply. Again, differences among the circuits as to which whether or not that's true. In my opinion, that's the way it should be, unless, and that's obviously burdensome, you are being asked to sign agreements every time you enter a store. Basically, you want to buy this software, here, sign this agreement, and we'll sell you this CD, so that you know what the agreement is, you know what you're doing the minute you buy it. It's not only after you load it up that agreement is shown to you, and then it's binding on a purchase that you've made before that. Now, as far as this idea that you can then introduce this digital product as well, we've got some cases on this kind of thing. There's actually a case right now called Disney versus Redbox, right? Where this issue kind of comes in place. Disney basically selling a pack that gives you a normal DVD of a movie, the Blu-ray, and a digital download all in one. Redbox buys it, sells the two DVDs separately, and then sells the digital download as well. Disney sues them, saying that all of these are subject to a EULA, to a license. It cannot be resold, definitely not a digital product. The judge comes back and says, this is a district court judge, and so it's not yet law, and it hasn't really been tested in the appeals level yet. It says, you know what? All those are separate items. The physical product are subject to first use amendment, and you cannot then take the code itself and say that the code then makes every single product there a completely digital product that is not subject to first sell doctrine. Basically, we can actually separate those elements are. And even when it comes to the code, since first the person purchased, the first Redbox purchased the product itself without being subject to any sort of agreement, you cannot then subject them afterward retroactively to an agreement that they only see if they actually enter that code into a computer. And I think that's the way I see the whole issue by Bethesda, that somehow them including provisions in their warranty that expire in the event that a transfer ownership is somehow going to subject the entire thing to a lack of first use doctrine. I think that kind of an approach is erroneous, because the courts can separate them. Basically, that is effectively a separate digital product from the software itself, from the game itself, and it's impossible for you to then actually retroactively make people subject to these EULAs, because later on they actually, when they open it up and they read and they have an opportunity to actually read the warranty, then they realize that they don't have the rights that they thought that they have. So I think that kind of a notion would not work. Now, whether or not they can use it as a way of getting around trademark violation because it's no longer the same, I think that's also false. I think that the idea that it's not the same product because you included a provision that was hidden from anybody within the box, nobody has any rights to it, that somehow then says that the product now is different. It's like taking the engine out of a Ford and reselling it. I think that's an erroneous way of thinking. I think that that something like a warranty is not really an element within the product itself. It's not an element within the game. The game does not run on that, and there's no, and unless there is some sort of an agreement that people read or actually have an ability to review early on when they actually buy the software, that says that, by the way, when you buy it, this warranty would expire if you ever decide to sell it. Unless they know that information, I think the court would separate the two things and say, you know what, the fact that your warranty expires does not make the resale of the game as described absolutely brand new a trademark violation. So I don't think Bethesda has much of a game, but they're playing in a sandbox where there's a lot of unsettled law, and as such, threats of litigation can do a lot to finish it. Again, they're going after some guy. He's not in the business of doing this. Just why are they doing this? Why are they going after some guy who's just trying to get rid of his PS4 game, which he has never, that's the kind of question. What's the motivation here? Everything is moving toward digital. And right now the law is in favor of Bethesda, saying that all pure digital products are not going to be subject to first sell doctrine. So why are they putting so much effort into something that seems to be a product that's not going to survive? How much longer are we going to have these physical discs with games? Is that really a huge problem for them? It was much bigger of a problem later on. I think that there's a real risk that again, I think they want to make a statement and they can't do it by suing a large company. Disney may have made a mistake when suing a Redbox there, because Redbox can defend itself. But I think that if Bethesda sued a larger company, there would be a claim here that Bethesda is misusing its copyrights and trademarks to actually control the market and raise prices on individuals by eliminating the gray market in their own products. So I don't think that Bethesda has much of a case, but I think that the fact that they're going after a little guy who doesn't really have much of a stake in this kind of a gray market means that they see some value going forward in the sale of discs, and they're trying to preserve it. They're trying to eliminate basically the growing gray market in their games.
lights are out and you stumble in the dark. You kept pushing on, but then you went too far. When your ship has sailed and all your dreams are lost, everything is wrong, you feel like it's your fault.